immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to today's special edition of our live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families and licensed attorneys come together to understand better how U.S. immigration laws apply in real life. My name is Nikita Bahadur and I'll be your host for today's discussion. How to successfully get a family-based green card while in the United States. Getting a family-based green card without leaving the U.S. is an option many families consider. The adjustment of status process, however, requires careful planning and close attention to immigration rules. Eligibility, steps, and documentation must all be handled correctly to avoid delays or denials. Today's webinar will provide a clear breakdown of how individuals can pursue a family-based green card from within the United States, what challenges may arise, and how to prepare effectively. To help break things down, we're joined by attorney Ibrahim Caglar, founder of Caglar and Associates, a New York-based immigration law firm. He holds an LLM from West Forest University and has extensive experience with employment-based immigration, family-based green cards, citizenship, and other immigration matters. He works with individuals and businesses navigating the U.S. immigration system. Attorney Caglar, thank you for joining us today. It's a pleasure to have you on today's special edition.
Thank you for inviting me.
Before we begin, a quick reminder that immigrationquestion.com is an educational and networking platform. The information shared during this session is for general informational purposes and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, or another platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding the family-based adjustment process. Let's dive right in. Attorney Caglar, to begin, can you explain who qualifies to apply for a family-based green card from within the United States and how eligibility differs between immediate relatives and preference category applicants?
Thank you. There are two main groups who can apply for a family-based green card while staying in the United States. The first group is immediate relatives of U.S. citizens. That includes spouses, unmarried children under 21, and parents of U.S. citizens over 21. The big advantage of immediate relatives of U.S. citizens that there is no annual limit. A visa is always available. Second, there are preference categories, as you just mentioned, like adult children of U.S. citizens, spouses of green card holders, siblings, and married children. These categories have annual quotas, which means wait times can be years. So whether you can apply from inside the United States depends on how you entered, whether a visa is available, and whether you qualify to adjust status in the United States. So not everyone inside the United States automatically qualifies for adjustment of status within the United States. You have to check how you entered, whether a visa is available, and whether you qualify to adjust status in the States.
For individuals already in the US, what are the requirements for adjustment of status, and what factors could make someone ineligible to file from within the country?
Thank you. So this is very important for those who wants to adjust their status in the United States. First, adjustment of status means applying for your green card without leaving the United States if you're already in the United States. But to qualify, you generally must have entered legally, meaning that you were inspected and admitted or paroled to the United States, and have a visa available. If you are immediate relative of your citizens, a visa is always available, and you must be admissible. Here is the important distinction here, that immediate relatives of your citizens have more forgiveness. Even they overstayed or worked without authorization, they can often still adjust their status. Of course, they have to be careful and transparent with the US government, but they can often still adjust their status without leaving the United States. But preference categories, preference category applicants are treated more strictly, if I may say. If you're out of status, you might not qualify. And if someone entered without inspection, that creates a completely different legal analysis. So before filing anything, I would recommend that the applicants review their full immigration history carefully, and if they have issues like being out of status or admissibility issues, there are waivers that they can use depending on their, of course, depending on their case. But it is, if they're U.S., if they are immediate relative of U.S. citizens, then they might have some options, even though they have. They can request waivers. So I hope this answered the question. Yeah.
Thank you. When it comes to concurrent filing, we know concurrent filing is often discussed in family-based cases. But when is it available, and what advantages or risks should applicants be aware of?
Great question. So concurrent filing means submitting the I-130 petition and the I-485 green card application at the same time together, right? So this is available when you are an immediate relative of your citizen, or your priority date is current in your category. The benefits are significant. First, you can apply for work authorization while your green card application is pending. You can apply for travel permission while your green card application is pending. You can start your green card application immediately. But here there's a catch. Filing too early, filing without strong evidence, or misunderstanding the visa availability can cause delays or denials. So concurrent filing is a powerful, but only when done, only when you check that you definitely qualify, and then you are an immediate relative of your citizen, and then your priority date is current in your category. So yeah, it is definitely something that I advise to my clients to do it if it is available for them.
In your experience, what documentation issues most commonly lead to request of evidence or delays in adjustment of status cases?
In family-based cases, the most common problems are documentation issues. So the first one that comes to my mind is that weak marriage evidence. So if you're filing if your filing is based on marriage, you must prove that your marriage is real. That means joint lease or mortgage, joint bank accounts, taxes filed together, insurance policies, photos across time. Uh, Basically, what you need to prove that you are married in good faith, and you have to prove that you have like you have to provide real proof of shared life. And the second problem that I face um, in family based cases is affidavit of support mistakes. So when you are filing a family based green card, your US citizen relative is sponsoring you, and then they have to show that the income, they have a sufficient income for that, and then if income should be properly documented. If income isn't properly documented, then USCIS will issue an RFE. They will request additional evidence. If and the most common mistakes that I see in family-based cases that require affidavit of support is that household size is often calculated incorrectly, or tax returns are missing. So the key is it's simple. When you are filing a case, a family-based case, you have to build a strong case from the beginning, and you have to file it when everything is ready to avoid any delays or RFE.
And how do prior immigration violations such as overstays, unauthorized employment, or entry without inspection impact the ability to obtain a green card while remaining in the United States?
This is a great question. Thank you. And it's one of the most misunderstood areas. If you overstayed a visa and you're married to a citizen, you can usually still adjust your status in the United States without leaving. Unauthorized employment, also generally forgiven for immediate relatives. But if you're in a preference category and you're out of status, that can block adjustment. If someone entered without inspection, on the other hand, adjustment is usually not available unless they qualify under special provisions like INA Section 245I, or maybe parole in place, or if they qualify for waivers that I mentioned earlier. But adjustment, if they request a waiver, they might still have to leave. So that's a very actually that's a complicated one. But usually they have to qualify under the section 245I, or maybe parole in place. And remember, if you leave the United States, this is, I think, very, very important for those who violated their status and now thinking to file an adjustment of status while in the United States. If you leave the United States after accumulating unlawful presence, you could trigger a 3-year or 10-year ban, depending on how many days you accumulated. So this is then you should definitely consult with an immigration attorney if you are in this situation, and the immigration strategy is very important in these cases.
Thank you for that overview, Attorney Caglar. This has been a very interesting session so far. For everyone watching, understanding the family-based green card process isn't about creating stress, it's about empowerment. Policies, processing trends, and documentation requirements can shift over time. These changes impact how cases are evaluated and what steps families should take. Staying informed allows individuals and families to make confident and well-planned decisions. If this is your first time joining, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Attorney Caglar, based on your extensive experience and your time with ImmigrationQuestion.com, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Thank you. The immigrationquestion.com is very helpful, I think, to bring immigrants and immigration attorneys together to help them to navigate the complex immigration um, uh, process in the United States. So and it's very helpful for immigrants, very useful for immigrants, for those who have cases in the United States or they are planning to come here, and for immigration attorneys to share their experience and their knowledge with immigrants. Thank you.
Thank you for sharing your thoughts on that, Attorney Caglar. Before we move into our live Q&A, let's tackle this very important question. What are some of the most common mistakes you see applicants make during adjustment of status process? And how can those mistakes be avoided with early preparation?
Great question. So I'll say, if you're just beginning this journey, if you're planning to file a family-based family-based petition in the United States, here's my advice. First, don't rush. Understand your full immigration history before filing anything. How did you enter? What was your status when you entered? Any prior denials? Any removal history? Any criminal issues? You basically you need to know your immigration history before filing your petition. Second, and if you're married to a citizen and you're going to file a petition, you need to start building your marriage evidence early. When I say early, you should start documenting when you start dating and through when you propose and then when you get married, like whole your relationship. Document your shared life from day one. Third, prepare your financial sponsorship carefully. As I mentioned earlier, many delays happen because income wasn't calculated correctly or household size wasn't calculated correctly. And finally, pay attention to timing. If you are in the preference categories, know your priority date, check the Visa Bulletin monthly to make sure that you can adjust your status if you're in the United States. And this is very important for your case. So preparation is very important, and understanding your full immigration history before filing anything. And if there are any issues in your immigration history, you should address them you should consult with an immigration attorney and address them before filing your case.
If you're joining us, we have been speaking with Attorney Ibrahim Caglar on how to get a family-based green card while in the United States successfully. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear answers from a licensed immigration attorney. Please share your questions in the chat or call us live on 516-703-3483, and we'll take as many questions as time allows. So we have our first question. Currently, is USCIS still granting interviews for family green cards while in the US?
Yes, it does. My experience with the family-based green card applications in the last couple of months that applicants the cases are moving forward very quickly, and they receive interviews, but they are still getting their green cards without, like if they can prove that their case is bona fide, good faith case, they still can get their green card, and USCIS will issue them a green card.
Thank you for that. Our next question is, if I applied for adjustment already and then get NTA, does that mean deportation?
Not necessarily. If you applied for an adjustment of status and then later you get an NTA, you will go to the immigration court, and there are two things that the immigration court can do. First, you can ask an immigration judge to terminate your case so you can continue your adjustment of status with USCIS, or you can ask the immigration court to adjudicate your adjustment of status. So it does not mean deportation as long as you can prove your case before the court or before USCIS.
Okay. Next question is, which paperwork is important to avoid RFEs for I-485?
So first of all, the form I-485, you have to fill that form correctly, right? And there, it's a long form, so you have to make sure that you answer every question. You should not leave questions unanswered, and if they apply to you, of course. And you should support the form with supporting documents, such as if you're filing for an family-based petition, and if you're married to a citizen, you have to include your marriage certificate. You have to include evidence of shared life, as I mentioned earlier, and also affidavit of support, and lastly but importantly, your medical examination report. You have to include that with your adjustment of status application to avoid any RFEs.
Okay, thank you, Attorney Caglar, and I think that's all we have time for today. Thank you everyone who joined us today, and thank you, Attorney Caglar, for sharing your insights and practical guidance. You can always visit immigrationquestions.com to ask immigration-related questions and stay informed about upcoming live webinars. If you missed any part of today's discussion, the replay will be available on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on our next live session tomorrow. Stay informed and stay connected.